Alabama's lease termination laws are among the most landlord-friendly in the country, and the process here is fast and straightforward. The governing law is found in the Alabama Uniform Residential Landlord and Tenant Act, Alabama Code, Title 35, Chapter 9A, along with the state's ejectment provisions. If you manage rental property in Alabama, you'll find the framework gives landlords significant flexibility to act quickly when termination becomes necessary. Let's start with no-cause termination. For month-to-month tenancies, Alabama requires either party to provide at least 30 days written notice before the end of the rental period. The notice must be delivered at least 30 days before the next rent due date. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice by March 1st at the latest. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required, unless the lease itself specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement under the same terms. Landlords who want to avoid this automatic conversion should communicate clearly in writing before the lease expires, and stop accepting rent after the term ends. For week-to-week tenancies, Alabama requires 7 days' notice from either party, with the notice expiring at the end of a weekly rental period. Now let's cover termination for cause. For non-payment of rent, Alabama requires the landlord to provide a 7-day notice to pay or quit. Under Section 35-9A-421, the landlord must deliver written notice giving the tenant 7 days to pay the full amount of rent owed. If the tenant pays within 7 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file an eviction action, known in Alabama as an unlawful detainer, in district court. Alabama's 7-day non-payment window is moderate by national standards. The notice must clearly state the amount owed, the period for which it's due, and the deadline for payment. Proper delivery matters. The notice should be served personally, left with someone of suitable age at the tenant's residence, or sent by certified mail to create a verifiable record. Here's an important detail about Alabama's non-payment process. The state does not provide a broad statutory right of redemption once the 7-day notice period expires and the landlord has filed for eviction. Unlike states where the tenant can pay at any point during the court proceedings and stop the eviction, Alabama's framework allows the landlord to proceed once the notice period has expired and the tenant hasn't paid. The court has some discretion, but there's no automatic right to cure by paying late after the case has been filed. This gives Alabama landlords meaningful certainty in the eviction timeline. For lease violations other than non-payment, Alabama uses a 14-day notice to cure, followed by a 30-day termination. Under Section 35-9A-421, the landlord must provide written notice specifying the violation and informing the tenant that the rental agreement will terminate in not less than 30 days if the breach is not remedied within 14 days. If the tenant corrects the violation within 14 days, the notice is void and the tenancy continues. If the tenant doesn't cure, the tenancy terminates at the 30-day mark, and the landlord can file for eviction. For repeated violations of the same type within 6 months of a prior notice, Alabama allows the landlord to terminate the rental agreement with 14 days' notice without providing another opportunity to cure. This escalation mechanism prevents tenants from cycling through repeated violations, committing the breach, curing it just before the deadline, and then doing it again. The second time around, there's no second chance. For serious violations, including criminal activity, drug-related offenses, and conduct that poses an immediate threat to health or safety, Alabama provides an expedited pathway. The landlord can issue a notice with a shorter timeline, and the court can schedule hearings on a priority basis. Alabama courts treat drug manufacturing and distribution on rental premises as particularly serious, and eviction proceedings in these cases typically move faster than standard lease violation cases. Alabama also has specific provisions addressing situations where the tenant's conduct constitutes a clear and present danger. If a tenant engages in violent behavior, threatens other residents, or creates conditions that constitute an imminent health or safety risk, the landlord can seek emergency relief through the court. One aspect of Alabama's framework that landlords should understand is the state's approach to abandonment. If a tenant vacates the property without notice, stops paying rent, and removes most of their belongings, the landlord can treat the lease as terminated due to abandonment. Alabama law requires the landlord to make reasonable efforts to re-rent the property to mitigate damages. The former tenant remains liable for rent until the unit is released or the original lease term expires, whichever comes first. Documenting the abandonment carefully, photographing the unit, recording the date of discovery, and keeping records of communication attempts is essential to protecting the landlord's interests. The eviction process in Alabama goes through the district court. The landlord files a complaint for unlawful detainer after the applicable notice period has expired. The court issues a summons to the tenant, and a hearing is typically scheduled within a few weeks of filing. Alabama's court process is designed to be efficient, and cases generally move through the system at a reasonable pace. At the hearing, the landlord presents evidence supporting the grounds for eviction, and the tenant has the opportunity to respond and raise defenses. Alabama courts allow tenants to raise defenses including improper notice, the landlord's failure to maintain habitable conditions under Section 35-9A-204, retaliatory eviction, and discrimination. If the tenant raises a valid habitability defense, the court may consider it when evaluating the eviction claim. Though, as we covered in our Alabama habitability video, the state's habitability framework is less prescriptive than in more tenant-protective states. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a specific period, typically 7 days, to vacate before the landlord can request a writ of possession. The sheriff carries out the physical eviction if the tenant doesn't leave voluntarily. The overall timeline from filing to removal is typically 3 to 5 weeks for uncontested cases, making Alabama one of the more efficient states for the eviction process. If the tenant appeals, the case moves to circuit court. During the appeal, the tenant may be required to post a bond to remain in possession. If the tenant doesn't post the bond, the landlord may be able to proceed with the eviction even while the appeal is pending. Alabama allows the landlord to seek damages in the same eviction proceeding, including unpaid rent, property damage, late fees, and attorney's fees if the lease provides for them. Combining possession and damages claims in a single proceeding is efficient and avoids the cost of separate litigation. On the tenant side, Alabama provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, the tenant can provide written notice under Section 35-9A-401 and allow the landlord 14 days to make the repair. If the landlord doesn't act within 14 days, the tenant can pursue remedies including lease termination. For essential services failures, no heat, no water, no electricity, Alabama provides additional remedies. If the landlord deliberately or negligently fails to supply essential services, the tenant can give reasonable notice and take action including procuring substitute housing at the landlord's expense or recovering damages based on diminished rental value. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Alabama has a significant military presence, including Redstone Arsenal in Huntsville, Fort Novosel near Dothan, Maxwell Air Force Base in Montgomery, and the Anniston Army Depot, making this provision relevant to a substantial number of tenants across the state. Alabama provides early termination rights for victims of domestic violence under Section 35-9A-303. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protection from abuse order a police report, or other qualifying evidence. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, and the tenant's liability is limited to rent through the termination date. Alabama's domestic violence provision also includes a lock change right. The tenant can request that the landlord change the locks to exclude the perpetrator, and the landlord must comply within a reasonable time. If the landlord fails to act promptly, the tenant can change the locks and provide a key to the landlord. Alabama strictly prohibits self-help evictions. Under Section 359A 427, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties include liability for actual damages and up to 3 months' rent, whichever is greater, plus attorney's fees. Alabama courts enforce this prohibition, and given how fast the legal eviction process is in Alabama, there's simply no practical reason to attempt self-help. Alabama's anti-retaliation protections are found in Section 359A 501. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint about habitability to a government agency, complaining to the landlord about maintenance issues, or exercising any right under the Landlord-Tenant Act. The statute doesn't specify a fixed presumption period the way some states do, but courts evaluate the timing and circumstances to determine whether the landlord's action was retaliatory. One practical consideration for Alabama landlords: the state's climate creates maintenance challenges that can overlap with termination situations. Alabama's hot and humid summers create conditions favorable to mold growth, pest infestations, and air conditioning failures. Tenants who raise habitability complaints about these issues during the termination process can complicate the landlord's eviction case. Keeping the property in good condition year-round and addressing maintenance requests promptly prevents habitability defenses from derailing an otherwise straightforward eviction. Alabama requires landlords to return the security deposit within 60 days of the tenant vacating the property, one of the longer return periods in the country. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit or provide the itemization within 60 days, they may be liable for double the amount wrongfully withheld, plus reasonable attorney's fees. Alabama limits the security deposit to 1 month's rent, which is important to remember when structuring new leases. For the complete guide to Alabama lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.